Whenever you're ready.
Thank you, Your Honor. Good morning, Your Honor. Stanford Lson, you have the privilege of representing Jack Chznar in this case before the court. Your Honor, what we have is an order of January 9, 2023, dealing with a trust and dealing with the issue of substantial revocation of that trust by Mr. Jesmer, who was the sole trustee.
Do you want to reserve some time for rebuttal?
I'm sorry?
Do you want to reserve some time for rebuttal?
Yes, please.
5 minutes?
10 minutes.
5 minutes?
I'm going to finish quick in the beginning.
Very well.
Yes, sir. And Wilbur Jezmer was together with his wife, they formed this trust back in 2009, I believe it is. And he died in 2016, August of 2016.
Let me ask you this. Doesn't what happened here meet the substantial compliance test?
Yes.
And the reason I'm asking that is because we have kind of what I'm going to call a trifecta, okay? We have Wilbur Jezmer, who is the grantor.
Right.
He is the trustee, and then at the time of his wife's death, he's the sole beneficiary.
Correct.
And so all of the rights as far as the sale and the direction of the sale proceeds, he was the only person that he would have had to notify. So, I mean, it wouldn't have been a superfluous act to have notified himself, and isn't that what the court found, that, you know, he was in control of everything?
Well, the Jesmer case decided by the Second District Court of Appeals and substantial compliance goes around that. They basically say, if you, in your trust.
Grassfield's had 2 trustees.
Yes, if there's 2.
We have one.
And that's, yes, we only have one. But we have him in many different
agreement-
capacities as a trustee.
But
He
the
has.
trust agreement in Grassfield is much different than the trust agreement in this case. That trust agreement in Grassfield required there to be 2. Very different in this case. We only have 1.
That's true. We only have one, but we still have the duties and responsibilities of the trustee.
Yeah, the duties and the responsibilities were under the trust agreement, which is what the court relied upon in Grassfield. We don't have that same scenario here to apply.
Well, the substantial compliance that was noted in the Grassfield case had to do with the notice and the written notice. And in this case, again.
Well, let me just read from you from the case and what you're talking about with the trust agreement. It said there shall always be at least 2 trustees. And in that case, they removed 1, which is why the court took a different stance than what the trial court did here. So I just don't see how Grassfield applies.
Well, Grassfield only applies because of the issue of not necessarily 2 trustees, but the issue of the written notice. And the written notice in this case is the same thing of what, if he's going to be the sole trustee, and there's not 2 trustees, and there has to be notice to the second trustee, he himself has undertaken the privilege, if you will, of being the grantor, the trustee, and the beneficiary, along with the contingent beneficiaries who are also beneficiaries underneath the trust.
My next question is what case law says that prospective beneficiaries have the rights that you're portraying here?
Well,
What rights do they have to challenge?
Okay, based upon the case law, and I believe it's in the Bingham case, that the trustees are to administer the trust for the benefit of the beneficiaries. And it doesn't identify who the beneficiaries are. It just says beneficiaries. It doesn't say contingent beneficiaries. It doesn't
And you're
say
referring to Brigham?
if he's the only sole
Are
beneficiary.
you referring to Brigham?
Yes.
Brigham, okay. And I think that case relies on a different statute, which is 737.403, which that statute's been repealed.
Right, it's been repealed.
Effective 2008. And the trust agreement in this case is December of 2009. So I'm not sure how those cases would apply.
Well, again, it's under 736.0802, trustee to administer the trust solely for the interest of the beneficiaries. It doesn't define beneficiaries. However, the definition of the beneficiaries is anybody that's to receive based upon the definitions of the statute of 736. So, I mean, it's like saying it's in a contract, not a contract case, but in another case where one person is the same people of all people, as in a corporation. If there's only one president, one director, one sole stockholder, you can go through and you have a responsibility of that one person for everything. You can also go through the corporate structure and pierce the corporate veil as to what his duties are and what his responsibilities are. And I liken that to this situation because this trust is an older trust, as you say, 2009. It was his wife, he and his wife.
It's actually newer than the statute.
Pardon me?
It's actually newer than the statute that the Brigham case relies upon.
Right. But, I mean, it's there for the benefit of all the trustees. But if you look at this trust, and in paragraph 2, the trustee says, the trustee is to be in charge of all the monies. All monies, and that if he is going to do anything with the monies, he, to himself, actually, based upon this breach of fiduciary duty, which he would need either a court order or permission from everyone, he still needs to figure out.
And how would prospective beneficiaries have the right to raise the breach of this fiduciary duty? What case holds that?
Because they have the right under the fact that they are the beneficiaries if the trustee mismanages. And the statute states if he mismanages, then the beneficiaries can come in and they can seek from the trustee.
And when can the prospective beneficiaries bring that action?
When they discover it.
Mr. Lipsey, your client.
And in this case, the beneficiary did not excuse me.
Mr. Lipsey.
I'm sorry.
Your client is a contingent beneficiary?
Yes, my client is a contingent beneficiary.
Has no vested.
As is the recipient of the funds.
Okay.
Which was Janet Jesmer.
But does a contingent beneficiary have the rights of a full beneficiary that you just discussed?
If during the time that the trustee has benefits, has the control of the trust, and the trustee commences with actions within himself and delivers the money to himself without court approval or without the approval of the grantor, then yes, I believe they can come back. And it goes under 7360802, and it gives through H the permissions as to what needs to be done. It says, subject to the rights of the person assisting the trustee as provided herein, unless the transaction was authorized by the terms of the trust, the transaction was approved by the court. In this case, the trustee, which is Mr. Jesmer, he received the funds as trustee. He executed all the documents as trustee of the trust. However, he then goes back 6 days later or 5 days later and has a check issued to himself as a trustee. He signs as a trustee. So as the trustee, he's still taking the money individually, which is without court approval and without the approval of the written approval, if you will, and that's what that's provided for in this trust. You need the written approval of the grantor, or if you want to terminate the trust, you need to sign in writing and send it to the trustee. He's all of these people. And I understand that the court can turn around and say, and did say in this action, there's no need to do this because you're all in one. But if that's the case, then where do you have a situation where the trustee, the grantor, or whoever, or the beneficiary, the sole beneficiary, converts the money, doesn't do right? And he didn't, because he gave the money solely to a single contingent beneficiary that was supposedly either a gift, which the evidence did not support, and the dead man statute does not support. But he also distributed it to himself, which was a violation of the trust. If the trustee has the money, and he is the trustee, I understand, he can do that, but he also needs to give written notice to the grantor. So everything is provided for in writing. He didn't give in writing anything. He didn't terminate in writing, and he did not take the money in writing. I'll reserve my time. Thank you.
Thank you, Mr. Lipsy. You'll have 5 minutes.
I'm sorry?
You'll have 5 minutes.
Okay, thank you.
Thank you.
Good morning, Your Honors.
Good morning, Mr. Moore.
I'm Terrence Moore. I represent the appellee, Jack Chznar. I think
It's like gravity is in the brief.
I'm
Maybe I missed it.
not sure that I did do so.
I mean, it's certainly distinguishable from what we have here.
Yes, it is. And I did cite the case law that Siegel versus Novak and Bean versus SunTrust, which established that if you take the corpus out of the trust, the funds out of the trust ceases to exist. And that's really what happened here. And I think it's clear from the court's questions, and it's clear from the statute, that the legislature set up these revocable trusts so that the governance of them is simplified so that you can almost accidentally be a trustee correctly. And they do so by two things, one being the provision that, and that is in 736.0603 per N1, that the trustee's duties extend only to the settlor while the trust is revocable. And of course here, the trustee and the settlor are the same person. So his only duty is to himself. Nobody else can sue him. The only person who can sue him is himself. And never seen a case where anybody's suing themselves. Maybe there is one. But the legislature set this up so that the trustees, if the settlor is still alive and the trust is still revocable, he can do what he wants. And indeed he could. And so that is also cited in another statute, 736.0813, wherein they refer to the statute I just mentioned. And the other provision that makes it easy to be a trustee is that the court, or the trustee must simply engage in what they call substantial compliance. And so there's no need for punctilious compliance with every aspect, every comma, every jot and every tittle of the trust. It doesn't have to be. 736.0602 says that a settlor, and that's in sub 3, a settlor may revoke or amend a revocable trust, A, by substantial compliance with a method provided in the terms of the trust. And then in sub 2, any other method manifesting clear and convincing evidence of the settlor's intent. Well, what do we have here? The trustee, same person as the settlor, what does he do? He arranges for the sale of the last asset in the trust, which is the Powder Puff condominium. He executes all the sale documents. He executes a separate document directing that the proceeds be paid to him personally, and he then takes them and deposits this check made out personally to him into the account of Jack Chznar. Now, these are all things that he did in writing, so there's clear written evidence of his intent, and it certainly is substantial compliance with the trust. And so it's clear that there's substantial compliance and that he legitimately took the funds that he, as settlor, had placed in this trust and took them out of the trust, leaving the trust with no assets. It was his intent to do so. He deposited them to the account of his daughter, Jack Chznar, who is the natural bounty of his affection. And so it is presumed that he intended to do so. So he intended to terminate this trust by taking the last asset out of it, and he did. And therefore, he complied with the trust in a substantial extent, and therefore, this court should not disturb the ruling of the trial court and should, in fact, affirm that ruling. The ruling certainly does not have an abuse of discretion. As a matter of fact, it is a paragon of discretion. It's one of the best written and best reasoned decisions I've ever seen by a court. It took her almost a year to prepare that decision. But she did, and it's very detailed, goes through all the relevant facts and applies them very reasonably. And I would ask, therefore, that the court affirm that decision. Thank you, Your Honors.
Thank you, Mr. Moore. Mr. Lipsey, you have 5 minutes for rebuttal.
Thank you. The only thing I want to reiterate, Your Honors, is to the extent that this is a trust, it is a joint trust. It is a joint trust of Mr. Jesmer and his wife, Eleanor. She predeceased. He is the grantor. Who terminated the trust? Did the trustee terminate it or did the grantor? We don't know. Because there is, as counsel states, is there an intent to terminate? Well, if there was an intent to terminate, he would have done so when he went to the lawyer with his daughter, Janet Jesmer, and had him prepare the trustee's affidavit to go to the closing, that he had the authority under the terms of the trust with which to do the transaction. If that's what he wanted to do, if he wanted to terminate it. But he didn't. And so therefore he goes to the closing with everything intact and with the trust intact. And with having been to the lawyer, they know what the trust is. They know what the trust terms are because they cited the exact paragraph in the trustee's affidavit. Did they substantially comply? No, they didn't. Do you have to give notice to everybody? The terms of the trust say yes, because that's a term of compliance of the termination of the trust by which the trustee then delivered the money to Mr. Jesmer individually. And the answer to that is, if he took it individually, he couldn't have taken it because it was distributed by the trustee, which the trustee has the money, but if he's going to distribute it, he needs consent of the grantor. And everything has to be in writing. If everything has to be in writing, only because, and that's what the court said, why do you need to do writings to yourself? Well, you need a paper trail. You need a paper trail to tell the people and tell the beneficiaries, this is what it is, this is how it goes, and this is how it happened. And then we didn't do that in this case. And that's why I'm asking that this court reverse and remand for the failure of substantial compliance, that the substantial compliance is not there. You can't go, as counsel says, this was the intent of Mr. Jesmer, or was it the intent of Mr. Jesmer as the grantor, Mr. Jesmer as the trustee, or Mr. Jesmer as the beneficiary? We don't know. Because the case basically says, and that's the case that says you can't go to the issue of intent. I'm sorry. Then that's the case that I've cited. I'm sorry. J.P. Morgan versus Siegel, 2007 case. Thank you. We, on behalf of Mr. Jesmer, we request that you reverse and remand with instructions.
Thank you, Mr. Lipsey. Thank you both.
Thank you.
We are going to take a 15-minute break and we will return for our last case on the docket.
All rise.